Order. Good afternoon. In honor of the judiciary, I will use my gavel for the first time this year. Welcome to the PSTE Subcommittee. We have 4 budgets today. We are going to go in the following order: Department of Veterans Affairs, Judiciary, Subsequent Injury Fund, Uninsured Employers Fund. For the Department of Veterans Affairs, we have our analyst, Ms. Rye.
Thank you, Madam Chair, and the members of the committee. My name is Yashodhara Rai, and I'll be presenting the analysis for the Maryland Department of Veterans Affairs, or MDVA. The graph on page 1 shows that the budget for MDVA has increased by $8.2 million in fiscal 25. Turning to page 2, 4 proposed deficiency appropriations totaling approximately $6.5 million is included in fiscal 25 budget, which comprises of $4.4 million in special funds, which includes $1.8 million from interment fees for eligible dependents on the Veterans in the Cemetery program, $1.1 million in gifts for Charlotte Hall Veterans Home, $1.6 million available from Bailey's Fund for the Charlotte Home, repairs and maintenance from previous contractor, and approximately $14,000 in service animal program. It also includes $2.1 million in federal funds for equipment in the cemetery program and Charlotte Hall facility upgrades and repairs, $270,000 in special funds from interment fees for eligible dependents of the Veterans in Cemetery program. There is also a planned reversion of $4.5 million in fiscal 25 budget from the $12.7 million in general funds that was included in fiscal 24 budget as supplemental budget number 2. This was for the procurement of new contractor for Charlotte Hall Veterans Home. We request the agency to comment on the reason for this planned reversion given the substantial increase in funds budgeted in fiscal 25. Exhibit 1 on page 3 shows a total of $63.4 million in the department's fiscal 25 allowance. $49.7 million is for the operation of Charlotte Hall accounts, of which 95.5% is used for contractual services for managing the facility and providing care to the veterans. Exhibit 2 on pages 4 and 5 shows that proposed budget increased by $8.2 million. The largest change of $13.5 million is due to the change in the structure of Charlotte Hall's management contract and its associated repair and maintenance costs. This is partially offset by the change in the equipment, land, and structures due to the one-time deficiency appropriation for equipment and Charlotte Hall facility upgrades. Moving on to the personal data on page 6. Fiscal 25 allowance includes 3 new regular positions, including a conversion of 1 contractual full-time equivalent to a regular position. There is an elimination of a part-time contractual full-time equivalent position. There were 16 vacant positions as of December 31st, 2023. 12 of these vacant positions were within the cemetery program. We request the agency to comment on the high vacancy rate and its efforts to fill these vacancies. Moving on to page 7, Charlotte Hall is under the new management contract starting June 6th, 2023. Exhibit 3 on page 8 shows that the Charlotte Hall continues to operate under capacity. The occupancy rate has declined from 403 residents in December 2019 to 227 residents in December 23. The facility has struggled with occupancy since the beginning of COVID-19 when it was unable to admit new residents, faced fatalities because of COVID, and experienced hesitancy of families to admit family members due to concerns around health, safety, and ability to visit. In a response to committee narrative in the 2023 JCR regarding Charlotte Hall, the department noted that it contracted with resident safety advocates and wellness nurses to conduct assessments and observe the implementation of the previous contractor's plan of correction and paused admissions to the facility in April 2023 during the assessment. The facility began readmitting residents on November 30th, 2023, which is 5 months after the change in the management contract in June 2023. This has also impacted the rebuilding of the census. We request the agency to comment on how its outreach activities can help increase Charlotte Hall's occupancy rate and other actions that the agency is taking to improve the occupancy rate of the facility. With the takeover of Charlotte Hall by the new management, the new financial provisions do not resemble those of the old contract. Exhibit 4 on pages 9 and 10 show a comparison of how the new financial provision compares to the old one. The second graph on page 10 shows the financial provision during the transition period. I'm sorry, that's on page 9. The second graph on page 9 shows the financial provision during the transition period to the new contract, starting June 2023 through fiscal 24, federal per diem reimbursement from the U.S. Department of Veterans Affairs and new funding streams from Medicare, Medicaid, and private pay are sent to the department directly. The Medicare, Medicaid, and private pay revenues are all new to the department effective with the new contract. The state directly reimburses the new contractor for its monthly operating expenses, approved capital expenditures, and management fee of $36 per day per filled bed. The graph on page 10 shows the financial provision starting fiscal 25, where the Medicare, Medicaid, and private pay revenues are deposited in the general fund, and the state pays the contractor for expenses through general fund expenditures. In a response to the 2023 JCR request for quarterly updates on Charlotte Hall staffing, the department notes that the hours of direct care provided per resident per day have increased from 3.7 hours in June 2023 to 4.7 hours in November 23. Also, as a response to the 23 JCR, as of November 2023, Charlotte Hall received an overall rating of 1 star in the Federal Centers for Medicare and Medicaid Services report, with health inspections receiving 1 star, quality measure receiving 2 stars, and staffing receiving 4 stars. We request the agency to comment on its strategies for improving the overall ratings of the facility. There were 35 complaints from residents of the facility from June 6th to November 30th, 2023. Of these, 19 were allegations of abuse, 7 of misappropriation, and 3 of neglect. None of these complaints in the CMS report resulted in a rating or a fine. 2 survey reports were submitted on November 7th, 2023, according to Section 1914C02A 1 and 2 of the state government article. One was an annual recertification survey for all of Charlotte Hall's skilled nursing and assisted living facilities conducted by the Veterans Affairs Office of Geriatrics and Extended Care of the Veterans Administration, and the other was a 3-year look-back survey of the resident trust fund accounts and systems at Charlotte Hall that was conducted by the State of Maryland Office of Healthcare Quality. No major issues were identified in both the surveys. The DLS recommends adopting committee narrative requesting the continued submission of quarterly reports in collaboration with the Charlotte Hall contractor on the progress of Charlotte Hall's operations, including efforts to increase staffing and residency numbers, number of resident complaints, and report rating or fine from CMS. Also, as a response to the 2023 JCR report requesting a report on MDVA's efforts to contact service members during their transition to civilian life, MDVA's plans to extend the job pipeline for veterans, existing partnership with state entities, and hiring programs for veterans in neighboring states. The department notes that it shares information on job fairs in its bi-weekly electronic newsletter and digital media channels. It is also exploring relaunch of Operation Hire Maryland, the 90-day Veterans Hiring Challenge led in calendar 2014 by the department's Outreach Program Director. We request the agency to comment on the status of the relaunch of this initiative. Page 13 is the DLS's recommended action. This concludes my presentation, and I'm happy to answer any questions.
Thank you very much. Any questions? Okay, seeing none, Mr. Secretary and whoever from your team, welcome.
Good afternoon, Chair Elfreth, and members of the Public Safety and Transportation and Environment Subcommittee. For the record, my name is Tony Woods. I'm the Secretary of the Maryland Department of Veterans Affairs. I'm also here with my Chief of Staff, Pete Pantzer, and our Director of Finance, Elena Charland. I also wanted to just thank Yasho for her very thorough analysis. It's been great to partner with her all throughout this process. I also want to take a moment before I begin just to really honor and recognize one of Maryland's great veteran leaders, a former member of the Maryland General Assembly, and my immediate predecessor, Secretary George Owings, who passed away in October. George served with distinction for many years in the General Assembly and then led this department over 2 different terms as secretary. And so I witness his impact every single day, and it's been a privilege to carry forward the baton of helping to build the second home in Sykesville. So I just wanted to honor him. This past year, it's been a privilege to lead the team in writing a new chapter and transforming the department to be even more responsive to the needs of the military-connected community, while continuing to strive for excellence in our core programs and in the care that we deliver at Charlotte Hall Veterans Home. I'm proud to say that the department is also reaffirming our commitment to drive down suicide within the military-connected community and striving to meet our mission to military families. We responded to your very thoughtful questions and recommendations in our written analysis, but we'd be happy to explain further or have more questions there if you'd like. We recognize you've got many budget presentations to hear today, and so I want to respect your time. With that, we are here in support of the governor's allowance, and we'd be glad to take any questions that you might have.
Thank you, Madam Chair. Mr. Secretary, great to see you and your team as always. We want to commend you on the swift actions on Charlotte Hall.
Thank you.
We're your partners in that as we go forward. We also want to thank you all for your partnership with the Veterans Caucus for both chambers. We think we have a dynamic relationship and working in tandem on legislation that makes sense that are veteran centric. So thank you very much. I will be in contact regarding, we still have something we talked about last year. We're trying to locate the Women's Memorial. And so there are a couple of placements that have been suggested to the caucus, and we'd like to share that with you.
Terrific.
Further date.
Made good progress. Looking forward to hearing from you.
Absolutely.
Thanks, Senator.
Thank you.
Thank you. Thank you. Sorry, it's a little tardy, but I appreciate everything that you continue to do, especially with Charlotte Hall. And I can ditto that same thing with our good friend and our chairman of the Veterans Caucus. Also, I look forward to maybe in time working with you with our veterans and their job pipeline. I know how important that is. We want to make sure that they have opportunity after they served or they continue to serve or maybe they're reserve or National Guard. But there's things that we can do more. I know the importance right now in our administration and other areas throughout our nation. There's shortages everywhere. So just knowing that if they have this certain skill, maybe we can develop something here or help them out so we can help our veterans, whoever they are, wherever they are, so we can continue to work with them. And if we can do that, I think it's a great thing. What the service they have done, we need to serve them and do for them. So thank you very much.
Completely agree, Senator. Thank you. If I could add quickly, one of the good news stories is that veterans actually have a lower unemployment rate here in Maryland. And as we all know, Maryland has the lowest unemployment rate in the nation. But I think all of us know that transition from service member to veteran can be a very tricky one. And I think, Senator, your point is spot on. One of the things I'm excited to partner with the Veterans Caucus to think about is, how do we recognize the skills that a service member is gaining while in the military, and then find ways to make it much easier for them to see a professional license or certification right here in Maryland, so we can attract even more to our workforce or retain more of them to have them stay here. So,
yes, sir. Just knowing their MOS, maybe getting that opportunity to know that, and just transfer from there to, like you just said, maybe a certificate or something that we could benefit them and help them and their family. So thank you very much.
Thank you, Senator.
Thank you, Mr. Secretary. I know you have a bill hearing. I have a couple of quick questions.
Of course, yeah.
We appreciate that everybody inherited a high vacancy rate coming in from this administration. Yours is still a little bit higher than I think this committee would like to see it at. Can you speak maybe to some challenges? If there are particular positions that are hard to fill, just give us a little context, please.
Yeah, so I'll call on Pete to sort of share a little bit this, because he helped to work this one, and it's also one that we've given actually a lot of thought. I remember this exact hearing last year, and saying we need to make sure we have a better story when we come in next year. And so I actually think I'm quite proud of some of the work that we've done to improve retention, which Pete can speak to. We're also, one of the things that I appreciated of Governor Moore is he said that we also need to be thoughtful about making our government more responsive, rather than just filling pins. And so to that point, we're in the process of converting a number of our open pins to focus on areas, particularly in our veteran benefits program, where we see actually very high wait times for your next available appointment. So, but I'll let Pete speak to any of the kind of key points that I've missed here.
Thank you. Senator Elfreth. Yeah, this has become a common question in our budget hearings. We really only have one problem classification. It's the one that keeps coming up. It's the veteran cemetery caretakers. They are the backbone of the veteran cemetery program. They're also the lowest paid employees in our agency. And I've been here almost 10 years, and almost from the start of my time, we've been working on bringing them up. Our caretakers today make 57% more than they did in 2015. So that's something I'm proud of. We have increased since 2019 our average caretaker retention from 1.9 to 4 years. So that's also something we're proud of. Recruitment is still a challenge. We have, along with anything the union has done, management has also done numerous pay increases and pay actions. What we're doing now is we're working with the classification and salary division at DBM to actually plan a sort of a remake of the entire classification. We'd like to use the federal caretaker, the VA caretaker classification, so that we do not communicate that this is a glorified landscaping job. This is almost a sacred trust, and we are starting the process of redesigning the classification so that we can pay more and attract better talent. And we're also working with them. We've already started discussions about establishing a non-competitive promotion series within the classification, because right now there's very limited room for growth.
Right.
So those are some of the things that we have done and some of the things that we're currently doing. We'll be working on the last two things this summer.
Okay, thank you.
You're welcome.
I have two more questions I'm going to ask, one, then go to Senator Rosa Pebb. Let me just start with the employment efforts, and we appreciate your work on this. And I'm sure the newsletter is wonderful, but it seems rather passive compared to what I hope Operation Hire Maryland will be. Can you speak a little bit to that? And I think this subcommittee knows one of the persistent vacancy challenges we have throughout state government is IT, which seems kind of perfectly suited for veterans to maybe fill those vacancies. Can you speak, what's your goal with Operation Hire Maryland, just so we can discuss it again next year?
Yeah, so happy to very quickly bring up, Senator, we created an initiative called Maryland Joins Forces, which is really focused on leveraging partners to help to do what they do best and augment and supplement our efforts as state government. We've entered into an MOU with Hiring Our Heroes, which is a nonprofit an initiative of the U.S. Chamber of Commerce Foundation. It's focused on hiring veterans and military spouses. So a couple of things, we are in the process now working with the Department of Budget and Management of becoming enrolled in what's called MSEP, Military Spouse Employment Program, which would make our vacant roles available online, and then proactively advertising to the military connected community and the military spouse community in particular. But you also will see us do more of a partner-led approach with Maryland private sector employers, Hiring Our Heroes, and helping to organize hiring events. So you'll see more proactive events throughout, which is what took place in that 90 days. You'll see it take place over multiple months throughout.
Wonderful. And of course, if you have events in our district, please don't hesitate to reach out. We will be there happily.
Of course.
Senator Rosa Pebb.
I want to ask about the employment issue with the caretakers. So how many folks are we talking? How many slots are there?
I think roughly about just over 50, if I recall.
About 50. What is
Which we have 8 vacancies.
We have really 5 vacancies that we can fill. 3 of our vacancies were established by the Board of Public Works to allow us to bring in former inmates who are veterans and had gone through the pre-release program. So we can only fill those with inmates, unfortunately or fortunately. So we have 5 right now, and we have plans right now to, as the Secretary mentioned, convert them to high need areas, reduce our overall agency rate, but we're going to keep trying to build the capacity we need, working with DBM and the governor to see if we can do that. And but there's 5 vacancies right now that we could actually.
And what do they pay? What does the job pay?
The average I have this
29,000, I
year,
believe.
today, 47, just over 47,000. And then,
Went from 29 to 47.
you said the average tenure is now about 4 years.
4
As
years.
opposed to 1.9.
yes, sir.
And what tends to be the age range of the folks?
I'd say it's a wide range. We have some who probably should be considering retirement, honestly, and then we have some who are probably in their 20s and 30s. So it's
widespread.
I think we have some wonderful caretakers. We also have some that, I think the pay really precludes sometimes the quality of employees we'd like. And that's not a blanket statement. We
No,
have
no, I
some
understand.
excellent
I
ones.
understand. And
Yep.
so typically, where do they come from and where do they go? If they're with you an average of 4 years and they're not with you for 20 years, where are they coming? What were they doing before and what are they doing after typically?
Well, it's an interview and hire classification. I don't think we necessarily have a lot of background information on them. So I can't tell you, but it really, the classification honestly requires a 6th grade education right now, which is another thing that we would probably be changing with the redevelopment of the classification. So it is presented as a very sort of a low skill classification, and that's what we're trying to change. So I can't answer beyond that, but we could get that for you.
Well, how about, do you know where people go when they say we're leaving? Do they tell you where they're going or why they're leaving?
Often they go to, if they can find a job that pays a bit better.
I'm sure. No,
yeah,
I'm sure that is.
They
but
would go there and I don't think there's any one field that they
okay.
go to.
That was kind of, I was trying to get a sense of
Yeah.
that. Well, let me make a suggestion like I make to everybody. Do not raise your educational requirement. Definitely raise the pay. Definitely be more aggressive in recruiting. Definitely make it a good job. But don't screen people out because of their education level.
Thank you. I think, we will consider whether we should even have the education requirement.
Yeah,
there at all.
I don't know about veterans caretaking. I wouldn't know how to do it myself.
Mhm.
But I bet you didn't learn a lot in 8th and 9th grade. So I wouldn't worry about that much.
Thank you.
All right, thank you. Thanks, Madam Chair.
Thank you, Madam Chair. And for the second bite, I just wanted to reemphasize one of the things that the senator mentioned. So it's very important for all of us to know where folks go when they leave.
Yeah.
Because you get a sense of why they left, what they're looking for beyond an assumption. And so that can kind of help you dial in a little bit. So I would love for you all to sort of work on a survey, exit interview survey, something like that. It doesn't take long. Just sit down and talk to folks. And in some cases, folks don't want to say it right then and there. Maybe 6 months or so, you reach out to them and say, hey, just want to kind of see how you're doing and where you landed. So
Sure. We can go back over the last couple of years and look at our
Absolutely.
exits and see what we can
Absolutely.
put together.
Be vital for us. Thank you.
Appreciate it.
Finally, Mr. Secretary, just a bit on Charlotte Hall. We completely understand that dipping from 400 to about 250 residents at the moment. And
Yeah.
our sincere hope, I think everybody involved, is to get that back up once we build trust in the community.
Precisely.
Do we have any sense of demand, especially as you're undergoing the build of second home? What is demand out there across the state for these facilities?
Yeah, so when we reopened admissions in November, we had a waiting list of about 35 veterans who were interested in moving into the facility. And so we've actually started to work through that waiting list now. We've been moving individual residences at a pretty steady clip, which has been great. I think to your point, though, one of the things that I realized throughout this entire process is how important it is for a veteran who resides there to have a loved one or a family member or a responsible party who is engaged. And so distance does matter. Charlotte Hall is in a beautiful location, and the 120 acres or so is a wonderful spot, but it's geographically far away from someone who might live on the Lower Eastern Shore or Western Maryland. And so that's why opening the second home in Sykesville is so important to us, because it starts to provide a geographically central option for folks. And that's something that we're eagerly exploring. We're also excited to share that we are now have basically provided Governor Moore with another option with the U.S. Department of Veterans Affairs. They've verbally agreed to give us an additional 7.7 acres at Perry Point. And so the governor will have that as an option if we wanted to explore the creation of a third potential home. And so homes more geographically spread throughout the state. And then, of course, working with the U.S. Department of Veterans Affairs to explore in-home care models, which is an area that is high on their priority list as well.
Wonderful. Thank you. Seeing no further questions, thank you all very much. Good luck with your hearing.
Thank you. Appreciate it.
Okay, we will move on to the judiciary and we have Jacob Polikoff. Jacob, take it away.
Thank you very much, Madam Chair. Again, Jacob Polikoff for the Department of Legislative Services to present the Judiciary Operating Budget Analysis. As a reminder, the judiciary's budget is submitted as part of the governor's budget, but it is developed without executive branch oversight. With that, we can start on page 1, where we have the operating budget summary, which shows that the fiscal 2025 budget increases by $31.8 million or 4.2% to a total of $788.5 million. General funds increased by $28 million or 4.2% in the fiscal 2025 allowance compared to the 2024 working appropriation, largely due to the creation of new positions, salary increases for judges and other employees, and contractual services, including security contractors and software licensing. Special funds increased by $4.7 million in fiscal 2025, mainly due to an anticipated increase in interest on lawyer trust accounts revenue, also referred to as IOLTA revenue, budgeted for the Maryland Legal Services Corporation. Those funds are budgeted for MLSC, but they are anticipated at this time, and funding can only be released from IOLTA when it has been realized. In the middle of page 2, we note that the fiscal 2023 court performance measures report, which was submitted to the budget committees in December 2023, highlighted improvements in the average case processing times for multiple types of cases in trial courts, as well as the continuation of certain issues with several case types that have been present for multiple years. These include average case processing time decreasing for criminal, driving under the influence, and traffic must appear cases in the district court, along with both large and small civil cases. Funding also continues to support Marylanders in need. The appointed attorney program, problem-solving courts, and other initiatives continue to deliver justice for Marylanders. These programs, in addition to initiatives from MLSC, help to ensure that Marylanders lacking financial resources for legal aid are able to receive justice in court. The appointed attorney program, which we'll talk about more in a moment, provided representation at initial appearances for more than 28,000 indigent defendants in fiscal 2023. And the mental health problem-solving courts, where many cases remain open for longer than 1 year, served 1,050 total clients in fiscal 23, with 331 new entries into the program and 63 successful completions. On page 3, we have a list of the operating budget recommended actions, which I'll be discussing throughout this analysis today. You'll see that there are 12 operating budget recommended actions. Some of them relate to each other, and I will make sure to discuss each one in turn and go over them again at the end. Moving to page 4, we see at the start of the performance analysis section, the bottom half of the page, that district court clearance rates have generally improved. The judiciary sets a standard for the time each case should take for processing from start to finish. Criminal, DUI, and traffic must appear cases are all set at 180 days. Traffic payable and civil small cases at 120 days, and civil large cases at 250 days. The district court handles a variety of cases, including all landlord-tenant cases, motor vehicle violations, misdemeanors, certain felonies, and claims of $5,000 or less, among other types of cases. This wide range of cases requires the judiciary to be staffed appropriately and have procedures in place to effectively process cases. Exhibit 1 on page 5 shows performance in the district court, which improved across the board as compared to fiscal 2022, with the exception of traffic payable cases, which experienced an average increase of just 1 day. In fiscal 2023, the district court processed cases below the standard time in 3 types of cases, an improvement of 1 from the year prior. Average case processing times remain well above the standard, as we see in Exhibit 1. For the remaining 3 types of cases, cases in the traffic must appear category experienced a significant improvement in fiscal 2023, a reduction of 59 days, but remain 98 days above the standard. Moving to the circuit courts at the bottom of page 5, the judiciary's report also covers circuit courts in every county along with Baltimore City. Circuit courts hold jury trials, unlike the district court, and deal with serious criminal cases, along with major civil cases, family law cases, and many appeals from the district court. Circuit courts are grouped into 8 judicial circuits. And as shown in Exhibit 2 on page 6, The average processing time in the circuit courts improved in 7 of the 9 tracked case categories in fiscal 2023. Limited divorce and juvenile delinquency cases took on average 16 and 7 more days than fiscal 2022, respectively. However, both remain below the case standards. Of the 9 case types, 7 had average processing times below the judiciary's set standard, an increase of 2 from the year prior. Cases involving a child in need of assistance, including shelter and termination of parental rights cases, remain above the time standard. CINA shelter cases were processed in an average of 39 days in fiscal 2023. That's 9 days above the standard, whereas TPR cases were processed at an average of 223 days. That's 53 days above the standard. These 2 case types were similarly above the standard in fiscal 2019, as seen in Exhibit 2 on page 6, which is the last year for which the judiciary provided data on average case processing times prior to fiscal 2022. In fiscal 2019, CINA shelter cases were processed at an average of 39 days, and TPR cases averaged 232 days. So the judiciary should work to determine how to bring these 2 types of cases in line with the standard, or examine if the circumstances that existed when the standard was set have changed to the point where the standard should be reevaluated. The judiciary should comment on specific issues that lead to extended case processing times for CINA shelter and TPR cases, and what actions can be taken to improve performance for those case types. And the Department of Legislative Services recommends adoption of committee narrative requesting the submission of a report on court performance measures for fiscal 2024. On page 7, we'll see a discussion of the problem-solving courts, or PSCs, which deliver justice and support for certain defendants. These courts are designed to provide both justice and resources, and also to reduce recidivism. Page 7 has a list of the different types of problem-solving courts, and these courts utilize partnerships with public and private entities to deliver positive outcomes for Marylanders who are in the justice system. This includes specialized dockets established for defendants with mental illness, where the focus is on reducing recidivism by arranging a treatment plan developed by court staff and mental health professionals. Veterans treatment courts serve defendants who are in the military, for example, and have conditions that include post-traumatic stress disorder, traumatic brain injuries, and substance abuse disorders, among other conditions. And those courts allow veterans to obtain treatment and services, including benefits to which they're entitled due to their service, while also resolving their criminal offenses. Other types of PSCs utilize similar approaches to deliver resources that deliver justice to offenders while also taking steps to similarly reduce recidivism. The judiciary has created problem-solving courts in 23 of the 24 jurisdictions in the state and continues to monitor outcomes from these courts and evaluates the potential for additional courts of the existing types. Appendix 3, towards the end of this analysis, provides information on the availability of PSCs by jurisdiction, and the fiscal 2025 allowance includes funding for 2 additional problem-solving courts, a truancy reduction court in Frederick County and a family recovery court in Washington County. As the judiciary continues to create new PSCs, the need for funding also increases. Performance metrics for PSCs are tracked in an annual report submitted to the General Assembly by the judiciary. However, the funding required for each court is not reported, and as such, it becomes difficult to discern whether the funding provided is being utilized fully and efficiently. In general, performance is measured by successful completion of the program. Clients who do not complete the program are classified as either an unsuccessful completion or an administrative closure. Administrative closures are reserved for cases discharged due to death, probation expiration, or when a client moves jurisdictions. Exhibit 3 on page 9 shows a breakdown of cases in mental health courts, which, as I've noted, can take longer than 1 year to resolve. We also have information on the truancy reduction courts, which are intended to improve school attendance and serve as an alternative to punitive measures such as prosecution for parents or in-school consequences for students. The program provides resources including social workers, counselors, and referrals to community-based services. And we see case performance metrics for this program in Exhibit 4 on page 10. The Department of Legislative Services recommends the adoption of committee narrative requesting a report on the total funding provided for each type of problem-solving court for fiscal 2024 and 2025, and the expenditures by type made in fiscal 2024 for the operations of the courts, as well as anticipated costs by type for fiscal 2025. At the bottom of page 10, we have a quick discussion of legislative priorities which have been implemented in fiscal 2024. The fiscal 2024 appropriation included $3.6 million in additional general funds to increase the appropriation for the Maryland Legal Services Corporation. This additional funding was utilized by MLSC to provide access to counsel in immigration proceedings. MLSC provides access to counsel in a number of different civil case types with this funding in courts throughout the state via grants to nonprofit legal services providers. By statute, Maryland Legal Services Corporation funds may only be used to serve clients with incomes at or below 50% of the median income in Maryland, and grantees are required to comply with annual program and financial audits to ensure compliance. Currently, MLSC's grant programs funded through the judiciary focus on foreclosure prevention, workforce legal services, judicare, which involves family law cases, and operating grants to support other legal services and fundraising efforts. On page 11, we see that the judiciary's fiscal 2025 allowance totals $788.5 million. The budget provides funding for 10 programs, including the trial courts, the appellate courts, the administrative office of the courts, and a number of other functions which support the judiciary's work. As we see in Exhibit 5 in the middle of page 11, the trial courts account for 65% of the fiscal 2025 allowance, with a further 18% allocated to the administrative office of the courts. Moving to page 12, we have information on the proposed budget change in Exhibit 6. As I mentioned, the fiscal 2025 allowance for the judiciary grows by 4.2% compared to last year. This growth is driven by a few specific things, which I'll highlight in the Exhibit 6. Salary and fringe benefit increases. These are related to both Judicial Compensation Commission recommendations for fiscal 2025, as well as salary increases and associated fringe benefits, including increments and the fiscal 2024 COLA for other employees, along with funding for 6 new positions, including a circuit court judge and staff in Prince George's County, and 3 employees for problem-solving courts. We'll also see on page 13 that there's funding for improved security at courthouses and other judiciary facilities, the increased funds for the Maryland Legal Services Corporation due to anticipated higher earnings from the IOLTA accounts, and funding for the creation of 2 new problem-solving courts, which I've just discussed. The compensation for judges and other judiciary staff is an item of interest. In December 2021, the Judicial Compensation Commission recommended that the judicial compensation increase by $10,000 per year from fiscal 2023 to 2026. The 2025 budget reflects that continued implementation of the judicial compensation increases. The fiscal 2025 allowance also includes the impacts of the fiscal 24 cost of living adjustment, which is essentially budgeted in the Department of Budget and Management and not yet reflected in the fiscal 24 working appropriation. The fiscal 25 allowance also includes $8.8 million for merit increases for non-judge employees at the judiciary. Funding for this purpose is also budgeted within the statewide account in DBM, and DLS recommends the deletion of $8.8 million in general funds made for the purpose of merit increases for judiciary employees because those funds are budgeted for that purpose within DBM. For the Maryland Legal Services Corporation, there's mandated funding for a new program, which is not included in the budget. Chapter 776 of 2023 requires the governor to include $225,000 for MLSC for a new affordable life, wills, and estate planning for seniors grant program. Because other funding is in the judiciary budget for MLSC, we're noting here that this funding is missing, and the judiciary should comment on why this funding is not included in the fiscal 2025 allowance, and the judiciary should work with DBM to fully fund the mandate through a supplemental budget. On page 15, we have data regarding personnel at the judiciary, and we'll see that as of January 31st of this year, there were 231.8 vacant positions, which is 5.57% of their total positions. That's below their budgeted turnover rate of 6.19% in the fiscal 2025 allowance. It's 25.5 positions below their budgeted rate. And as I've mentioned, the fiscal 25 allowance includes 6 new positions. The fiscal 2025 allowance for the judiciary includes those 6 positions, one of which is a circuit court judge for Prince George's County, along with 2 support staff. The request for a new judge has been made as part of the submission of the judiciary's annual report on the need for judgeships. The report for fiscal 2025 did certify a need for 6 judgeships. However, the judiciary included only 1 position due to its recognition of budgetary considerations and space constraints within courthouses. DLS is recommending the adoption of committee narrative requesting a report on judgeship needs for fiscal 2026. There are also 3 new positions for problem-solving courts, 1 case manager and 2 coordinators. And there, as previously mentioned, the judiciary's vacancy rate is below the level that would be needed to meet its fiscal 2025 turnover expectancy. The percentage of positions vacant is below the 7.34% rate reported in December 2022, and there is currently only 1.74 positions, which have been vacant for longer than 12 months. On page 16, we have information regarding the appointed attorney program, which provides representation, as I mentioned, at initial appearances before district court commissioners. These attorneys are private attorneys who are compensated by the state at a rate of $60 an hour. And each year since the program's inception, the budget committees have required the judiciary to report on the cost of the program. Data from fiscal 2023 shows that the full appropriation of $9.25 million was not used, with over $500,000 remaining unspent. Exhibit 7 in the middle of at the bottom of page 16 shows a breakdown of spending by county, including a comparison with the amounts that the judiciary originally budgeted for each jurisdiction. Each year, the full appropriation has been restricted by the budget committees in order to ensure that the program is fully funded. In both fiscal 2022 and 2023, the full appropriation for the program was unused. Therefore, DLS recommends that the fiscal 2024 appropriation for the appointed attorney program be reduced by $500,000 to align the amount budgeted for the program with fiscal 2023 expenditures. Additionally, DLS recommends that the funding for the program in fiscal 2025 be reduced by $500,000 to align with recent expenditures. There's also a recommendation from DLS regarding the recommended adoption of budget bill language, restricting $8.75 million of general funds to be used for the implementation of the appointed attorney program, including adoption of a committee narrative requesting a report on the costs and utilization, as in other years. The judiciary has continued to make progress on major IT projects, as we see at the bottom of page 17. In December 2023, they submitted a report on the major information technology development projects as requested in committee narrative. This report provides information on the MITDP's major information technology development projects, included in the report on planned spending by project through fiscal 2028. The total spending for fiscal 2025 is expected to be approximately $19.7 million, as we see in Exhibit 8 on page 18. This exhibit shows each project along with planned funding from 2024 through 2028. The report indicated that 4 projects are due to be completed in fiscal 2024, and that 5 new projects are commencing in fiscal 2025, with initial funding appearing in the fiscal 2025 allowance. A description of all of the MITDPs that the judiciary is currently facilitating can be found in Appendix 2 of this analysis. And among the projects concluding in fiscal 2024 is the Maryland Electronic Courts, or MDEC project, which has been delayed several times and is planned to roll out in Baltimore City in May of this year. Funding for MDEC is not ceasing entirely, as one of the new projects is called MDEC Optimization, which is intended to incorporate additional functions and features which have been requested during the initial rollout. Excuse me. DLS recommends the adoption of committee narrative requesting a report on the judiciary's major information technology development projects, including the anticipated costs of such projects through fiscal 2029. The Land Records Improvement Fund funds the judiciary's major IT projects. That Land Records Improvement Fund is also known as the Circuit Court Real Property Records Improvement Fund, which statutorily receives revenues from surcharge and copying fees, along with funding expenditures in addition to the MITDPs, including circuit court offices, e-filing operations, and maintenance, along with MD Land Rec and the electronic land records online imagery operations and maintenance. MITDP spending is higher in fiscal 2024 and 2025 compared to recent years, and is forecasted to remain at a high level through at least fiscal 2028. Additionally, MITDP spending was forecasted in the fiscal 2022 report to be $17.7 million in fiscal 2023, while the actual figure reported was $10.5 million. Even with increases in major information technology project spending and circuit court expenditures, the balance in the Land Records Improvement Fund at the conclusion of fiscal 2028 is projected to be above $35 million. In recent years, the judiciary has forecasted a structural shortfall in this fund. Several chapters within 2022 and 2023 authorized the judiciary to transfer up to $12 million in general funds to the Land Records Improvement Fund, also in fiscal 2021. As shown in Exhibit 9 on page 20, the full amount authorized was transferred in fiscal 2021 and 2022, while $5.6 million in general funds were transferred to the Land Records Improvement Fund in fiscal 2023. Data from fiscal 2021 and 2022 shows that the transfers of $12 million in general funds were not needed in order to avert a structural shortfall, and that the Land Records Improvement Fund would not have been depleted before fiscal 2028 had the funds been reverted to the general fund rather than being transferred to the Land Records Improvement Fund. DLS recommends the adoption of committee narrative requesting a report on the revenues and expenditures of the Land Records Improvement Fund, including details on expenditures for circuit court offices. On page 21, we have the start of the list of operating budget recommended actions, which I'll go through quickly. The first is a reduction provided that $5.6 million in general funds made for the purpose of operating expenses are reduced. The Chief Justice is authorized to allocate the reduction across programs within the judiciary. That action is designed to reduce the fiscal 2025 general fund appropriation for operating expenses to more closely align with actual spending. The second is to remove the previously mentioned $8.8 million in general funds for the purpose of employee merit increases, which is double budgeted within DBM as well. The third is to reduce $500,000 in general funds for the provision of attorneys at initial appearances before district court commissioners. That's the appointed attorney program. We're also recommending the addition of language restricting funds for the implementation of the appointed attorney program, along with requesting a report on the appointed attorney program costs and utilization. Item number 6 is the annual court performance measures report. Item number 7 is the problem-solving court performance and funding report. Item number 8 is the major information technology development project report. Number 9 is the Land Records Improvement Fund balance report. Number 10 is the judgeship need for fiscal 2026. And then items 11 and 12 number 11 is a technical action to implement number 12, which reduces funding for the appointed attorney program in fiscal 2024 in order to better align with the funding in order to better align with fiscal 2023 expenditures of $8.6 million. And with that action, $8.75 million remains available. And with that, I am happy to take any questions.
Thank you, Jacob. Thorough as always. Senator Rosepap.
A couple of questions, and so you can move on to other folks if you want. So I don't do them all at once. First question is, actually, this is a better question for them. Let me just give you the question that I raised with you earlier. Is fees collected by the judiciary, some of them go into special funds and some of them go into the general fund?
Right. So there are some fees, as I mentioned, some surcharges which go into the Land Records Improvement Fund, for example, and then there are others which go into the general fund, and the judiciary is responsible for tracking which ones go where.
I mean, do we know quantitatively how much of the general fund, how much goes into the general fund?
I do not, Senator, but I could certainly track down that information provided to you.
Could you track down how much and kind of what are the big buckets? That's 2 questions. The third question is, how recently have they been adjusted?
Yes, sir. I'll have to track down that info for you, but
Thanks very much. Thanks, Madam Chair.
Thank you, Senator Rosepap. That actually was an issue we tried to explore over the interim when it came to impaired driving, and those fees actually go to the Transportation Trust Fund, but we should have that broader conversation. Jacob, my only question for you is, it's my understanding that the governor's budget does not include funding for counsel for immigration proceedings moving into fiscal 25.
You're referring to the $3.6 million from last year, right? No, it does not at the moment, at least as far as I can tell.
Okay, thank you very much. Mr. Chief Justice, welcome, and anybody from your team. Have you settled into that new title yet?
No. But thank you for asking. Madam Chair, members of the subcommittee, thank you very much for having us. We are joined here today, if I may, by 5 of our elected clerks of court. If you'll allow me to introduce them. We're joined by Clerk Sandra Dalton of Frederick County. You can stand up when I call. Clerk Catherine Hager of Queen Anne's County. Clerk Charisse Kennard of Kent County. Clerk Kevin Tucker of Washington County. And Clerk Lisa Yates of Charles County. We're all their budgets are obviously part of this as well. So, but we very much appreciate the subcommittee hearing us today, and very much appreciate the very thorough analysis of Mr. Polikov. The judiciary's mission, as you know, is to provide fair, effective, and efficient justice for all. Our budget, which makes up 1.3% of the state's overall budget, is geared toward accomplishing that central and essential mission. We do that not just through the basic operation of the courts, but through programs and procedures that are designed to make the courts more accessible, responsive, and responsible. And a lot of the elements of the budget that you're reviewing are intended toward that. So we look forward to your questions, and if we can go through the response to the recommended item. We had that in writing, but we can go through them if you want. Okay. So and most of the recommendations we accept or concur with, and that deals with the first recommendation of the reduction of the $5.6 million in general fund. On the recommendation 2, which relates to the $8.8 million that apparently is in our budget and DBM, it has historically been in our budget, and we've consulted with DBM and believe that it should remain in our budget and come out of the DBM budget. We certainly agree that it shouldn't be in both, but historically it has been in ours, and that's the way that we both think it should be going forward. We concur in the recommendations related to the appointed attorney program, and the reports that have been requested. One exception to that is with the report with our problem-solving courts. We concur with the recommendation to have that report, but there's one of the elements of the narrative was to have it broken down by the program within the court. And the difficulty of that is that a lot of these programs share resources, and so the way they've developed, there might be a program manager that operates in multiple types of problem-solving courts in the same jurisdiction. We also have courts that span multiple jurisdictions and share resources across those jurisdictions. So we do a report every year that gets detailed into the use of those funds. The element that is that would be problematic is related to that breaking it out where they have shared resources and funding across those. We concur with the other reports that have been requested through the major IT projects. The next item on which I wanted to mention was with respect to the SINA and TPR cases. Those are the 2 examples where the average case time is in excess of the standards that we that we apply. The first part of our response is that we use average case time, and that's an appropriate use, but we think that even more appropriate is median case time. With respect to those 2, the only case area that is above that standard when you apply the median is the TPR cases. But with respect to, I think a broader point with respect to both types of cases, the standards that apply for those cases are appropriately aggressive. They are aggressive, but appropriately so based on the issues that are involved in those cases. But there are a lot of challenges in those cases because of the interests involved, losing somebody's parental rights and the disposition of children who have been subject to abuse or neglect. It happens in those cases that they cannot sometimes be moved consistent with the due process rights of the people involved and the best interest of the children at the speed that those appropriately aggressive timeframes exist in. And so that happens in these cases where, frankly, everybody agrees sometimes that you need a delay in order to allow something to happen. And so that is a unique factor with respect to those cases where we have been very aggressive in setting those timeframes, and sometimes that interferes. I'm also I should say I'm joined by the State Court Administrator Judy Roop, by a Chief Judge of our District Court John Morrissey, and by the Executive Director of MLSC Michelle Siri, who I think can more appropriately address the final comment dealing with the amount that was set aside for the Affordable Life Wills and Estate Planning for Seniors Grant Program.
Thank you so much. Good afternoon, Madam Chair, members of the subcommittee. Thank you for having me. As the Chief Justice said, my name is Michelle Siri, Executive Director of Maryland Legal Services Corporation. And yes, as the report says, in the 2023 legislative session or 2022 legislative session, a bill was passed to create a special fund for affordable life and wills planning for seniors. The statute that is now in place says that funding shall be appropriated by the governor starting in FY25. It is my understanding that that is not in the judiciary's budget and also not in anyone else's budget. And that's about all I know.
Sounds like we have to find it somewhere. Okay. Any other thoughts, Mr. Chief Justice, or?
No, and that's,
Okay.
for that perspective, it's not our funding, it was to be included, so that's why it's
Okay.
wasn't what we provided.
Thank you.
But no, thank you. That's all I
Okay.
had to comment on.
Senator, I'm gonna ask one question and then I'll, to Senator Rosepep's question and Chief Judge Morrissey, you and I have had this conversation. It was a bit of a struggle getting some data from judiciary around impaired driving as we're thinking through funding and mechanisms to fund our trauma system, which is directly impacted by impaired driving. But to Senator Rosepep's question, and we've had this conversation with Maryland Insurance Administration, a few other kind of fee collecting agencies, we often can foresee some policy challenges or opportunities in the budget. And you are the best suited to kind of recommend to us whether certain fees or fines are actually suitable for, what they're intended to do, which is to dissuade people from negative behavior. So I would just ask you to keep an eye on that moving forward. If you just don't feel like something is strong enough, we would always love to hear because you're the folks on the ground.
Sure thing. Thank you.
Thank you. Senator Jackson and then Rosepep.
Thank you, Madam Chair. Great to see you all. Two quick questions. One is a follow-up on the chair's comment regarding the fees and Senator's comment on the fees. A few years ago, the Maryland Police Training and Standards Commission, the traffic citation dollars used to go to that facility. We have supplemented those since they no longer go to that facility. Could we get, or do we have a breakdown of the numbers, the consistent numbers regarding the traffic fees that come into the courts and where they're routed? If we could get that. And then secondly, with the TPRs, I certainly understand and appreciate the aggressive timeline on that. Certainly would like to be kept a little closer with regard to how those cases are going. I mean, there's tremendous impact, everything from the system itself, the family network, obviously, and our school system and our community schools as well. So if we could get some information on that as best you can. So appreciate that. Great to see you all. Thank you,
Senator,
Madam Chair.
what time frame were you looking for the data in your first question?
Oh, I'm sorry. Yeah, if I could get that, but then before we leave the before we Sunny die.
I thought you were gonna say this evening.
No, I'm not gonna do that to you. I'm not gonna do that to you.
Let me rephrase.
Well,
For
well,
how many
actually-
years going back?
Oh, for how many years going back?
Yes.
Well, the first question, I mean, when the decision was made that the legislature would no longer direct those funds to the Training and Standards Commission, I'd like to know from that point where those dollars have been redirected.
Sure. It's all, just so everyone knows, it's all legislative.
I got you.
It's complicated is the best way
Yeah.
I can say it. And
Got
so there's a fine that you would get in a traffic case that's under the transportation article, usually sets the amounts of those, or as the chief judge of the district court, I'm authorized to set those. So a fine may be $100. Then there's court costs, and then there's the criminal injury compensation fund. In among those court costs and the criminal injury compensation fund, they go to different little areas on those. So the actual fine that we do goes to general fund. So we don't collect anything. And then the costs in the CICF go to all those various ones. And I'll have a breakdown of all those for
And
you.
I do appreciate that because as the chair mentioned, they're all intertwined. So we're just
I have a
trying to make sure that
PowerPoint presentation that I did earlier on that still confuses me at times, but I really have to focus on it because it is that complicated.
Yeah,
It's
I appreciate that.
depending on the case type, and each one has its own different variation. But I'll certainly get those to you.
Thank you. Appreciate that.
By signing day.
Or for the budget?
We'll get working on it. We'll get working on it soon. I'm looking back at my chief clerk and my finance director.
Yeah, thank you. First question is on these problem-solving courts. What are the constraints? Well, not either constraints or reasons they aren't bigger.
Well, there's a lot that goes into that, but the way we have them organized is they're led by judges in those jurisdictions that are willing to take it on, and they are they're led by judges who want to take it on and build the program and initiate it in those jurisdictions. What the note I got was voluntary, which is a part of it, meaning we don't have the authority to send people to problem solving courts, meaning to make that part of the disposition if they don't agree to do it. And so when the problem solving courts are set up, they're set up to withstand a certain capacity of individuals coming in, but the individuals have to be willing to participate in the program, and then they're frankly very arduous, difficult programs to complete, and appropriately so, because the idea is to have somebody be able to be diverted from at least part of the criminal justice system, and complete the programs as a way to recover from whatever it is that the specific problem-solving court is addressing. So we have capacity limitations for resources. We have the limitations, meaning that somebody has to be willing to take that program on and run it and take ownership of it. And we have some amazing judges who have put a tremendous amount of effort into these programs, which goes well above and beyond what they do in their normal dockets. And then you have the element of the individuals who have to be willing to comply with it.
Right.
And on that point, I'll say that some of the reforms that have come in recent years that have reduced penalties for certain things have also substantially reduced the incentives that some of these individuals have to actually participate in the program, because if where somebody might have been willing to participate in the program to be
No, that's a big idea.
it is, and so that's obviously policy decisions, but that's why the state, for example, used to have quite a few juvenile drug court programs, and they're no longer there because it's not in the interest of the participants to participate in them, because there's not the incentive structure has changed.
I presume you've shared that data with the Judiciary Committee and Judicial Proceedings as they've been dealing with these penalty issues?
I don't know that we've shared that directly, but that's certainly part of. I mean, when we've been asked why, I remember when I first asked the question, seeing we had like 9 juvenile drug courts a few years ago, and we're down to 1. Why? And the answer is because before, when somebody looked at it and you laid out what was necessary in order to.
I get it.
Yeah.
But I never thought of it before. That's why I'm saying that maybe everybody in Judiciary and Judicial Proceedings knows all this, but I certainly never thought of it before.
I don't know that.
Okay. I encourage you to share. Because I mean, that's exactly the chairwoman's point about policy and budget. And so the big argument you're making is supply and demand. So it's the demand by the criminals and it's the supply by the judges. And you have to have both.
Yeah, sure. Go ahead.
So, Senator, thank you for the questions. We're very proud of the expansion that we've had of our problem-solving courts since I've been doing this for 10 years as a chief judge, and it's expanded by probably a third or more of courts expanding. One of our challenges has been in both the circuit and the district courts is that the smaller jurisdictions may not have enough people to support, enough participants to support a problem-solving court. And through some innovative.
What participants mean? Is that the criminal or the judge?
Criminal. That would be the
Okay.
criminals, right? I don't like to call them criminals, but I would say, yeah, defendants or individuals,
but not the
individuals
judge.
involved in the justice system. In what we've done, it was through the innovation of a couple judges down on the Lower Shore, and in Dorchester in particular, we've created a regional veterans court, and it's not just district court, it's circuit court, and we've worked out the business process for that so that perhaps Dorchester itself couldn't support, there weren't enough people.
I got it. Economies of scale.
Exactly. So we have that, and we're
makes
actually
sense.
doing that out west now too for the smaller counties out there. And we're very proud of that work, and it gives us the ability to things that we can provide in the large jurisdictions, we really want to be able to
Gotcha.
provide in the
No,
small
that makes good
jurisdictions.
sense. Well, but to the extent that you'd like to expand, what would you say is the bigger challenge, the supply or the demand? The lack of judges taking it on, or the lack of defendants wanting to use them?
I would think it would be demand. It's, you know, and you'd probably want to ask this question of the Office of the Public Defender, because there's an analysis that goes on as to the length of the potential sentence that you may have and how long the drug courts. Typically, they're going to take 18 months to complete, and that's national standards as to how long something like this would be for the effectiveness. And if there may be decisions made, if the decision is made that the sentence may not be 18 months.
No, I
the
got
individual may
you. So that issue related to sentencing is the elephant in the room.
As a practicing attorney prior to being a judge, I had conversations like that with my clients all the time.
Gotcha. Is there a resource constraint? Or if you got the judges willing to do it and you got the defense willing to do it, but what other resources do you need?
I mean, so I think that as long as, I think the General Assembly has been behind the problem solving courts that we've had. So I think that when we have looked for those resources, we've been able to get them. I think that's showing the success. I mean, all you need to do is attend one of these graduation ceremonies to see the difference that it makes in real difference it makes in people's lives to be behind it. So I think I think that we have been successful in getting the resources when we've asked for them.
And Senator, it's
that.
a very purposeful approach that we take to these problem solving courts. They have to be approved by the Chief Justice's court.
Yeah.
We have, programs where we figure out how many people we think are going to come in, what our resources are needed, and you all have been very, very kind to us in granting us the requests that we need. So
I appreciate that.
and there's 3 in this budget right now.
I'll stipulate that we're kind. I'll go with that.
There's 3 in this because we're ready. We 2 judges have stepped up and got new programs going, and the 3rd is the reentry program run by Judge Pastore in the city.
Yeah.
And that's expanding, and we need an additional person because of
I got you.
it's really this magic in the sauce is the follow-up with these individuals, and that's
Sure.
what case managers provide.
Got you. Okay, thank you. That's very helpful. Appreciate time goes on more information about this in ways from a policy point of view that we can expand it to the extent you think it works. I'll take a break.
Well, just on that note, I would hope you would entertain if we maybe brainstorm some budget language around effectiveness as defined as, I would suggest perhaps recovery from a substance use disorder or lack of recidivism on behalf of the defendant. Whatever metrics you believe kind of point towards effectiveness of these courts, I think this subcommittee and General Assembly as a whole would be incredibly interested in exactly what that looks like.
Last year, our report demonstrated a 9% reduction in rearrests.
Okay.
So happy to share additional data as it's broken down by problem solving.
That's very helpful.
Yeah, switching topics to fees. I mean, I have the impression, and I don't go to court very much. So I have the impression that they're filing fees or they're fees that folks pay in different kinds of situations, different kind of cases in court. Have I got that right?
There are filing fees to open a case, and certainly in criminal dispositions, there can be fees.
So that's sort of the question I was raising with Jay. I'm trying to understand how significant that is. And again, they go to the general fund primarily. But I mean, is it millions of dollars? Is it tens of millions of dollars? Is it billions of dollars? Is it $1.50?
I don't.
We can certainly get you some of that information.
That'd be good.
I'll say that there's a larger fines and fees conversation that's happening nationally that deals with a situation we thankfully don't have here, where fines and fees provide the backing to operate courts and the incentive structure that creates, which is a bad one if your own budget relies on charging those fees. The structure here, where our fees don't go to fund the courts, they go to the general fund and they go to these others, is much better from a policy standpoint, but it also means that it's less relevant to our operations. So we need to find that.
But it is relevant to our operation.
I understand completely. I'm just that's why it's a good thing that it's not necessarily on the tip of our tongue for what we're trying to.
Fair enough. But if you can get us that data, what I'd really like to know is how much and kind of what are the major buckets of kinds of fees. Great, thank you.
Every year we develop kind of themes throughout these budget hearings, and that's certainly one we've heard from a couple of budgets, and we'd be curious with a follow-up on that.
One of the things, Senator, in the district court particularly, is that we've purposely kept our filing fees low. We derive from the People's Court historically, and it's an access to justice issue. And I think that's what Chief Justice referenced, where there's there's a movement to reduce those fines and fees for everyone. And we're already historically low. You've probably heard about that in the landlord-tenant setting. We have very low fees. It's not just landlord-tenant, it's everything. And that's purposeful.
Right. I think it's a balance to be struck here. So that's why I think we want
May
to.
very well be.
Yeah. Thank you. Senator Solomon.
Thank you. Now, I want to throw a curve here a little bit. But one thing that I talked about last year that was a concern was public safety for you. When you go into the building before you go to the courtroom, you have to go through the screening and you make sure you take everything out of your pockets. And a lot of buildings I've seen with their state or local, these have little pillars in front before you can go in there. And in one of my court areas, they don't have that. And they've had vehicles come up. They literally had the Essex court area shot up. And it was pretty bad. And I found this out later on when I walked into one of the rooms and was able to go there to witness for somebody, and they knew who I was, and they asked me if they could talk to me because they still don't have any security like that there, and they're concerned. And they're retired police officers, state police sheriffs, some of them that work there, and I'm concerned about them. I am. I like to see maybe some pillars up front of there to make sure that these workers are safe before anything could happen, because they've seen what happened before. Is there some way that we can maybe look into that, or maybe we've done that before in this area, and we can do the same here to make sure that that concern is answered?
Yeah, absolutely. That's something that is very much a concern of ours. And we are currently undertaking a project to do security reviews of all of our court facilities. It's underway, that we've already sent out basically surveys before the physical survey happens to be returned to do an analysis of all aspects of security in all of our court facilities. Teams will be going out to each building to look at all of those things and everything else within the courthouse. We also have separately in our security bill that has already been passed out of the Senate and is pending in the House, a legislative task force that would also be looking at some specific security issues within courthouses. And then we have recently formed, I think 4 or 5 months ago, a task force within the judiciary that is overseeing all of those court by court reviews and looking at issues like screening in courthouses and outside of it as well. So we have multiple initiatives underway that address those security concerns.
And
Thank you.
Senator Stalling, I'll speak specifically to Essex because that shooting occurred in the wee hours of a Sunday morning in December of 2021, I believe. And myself and my building engineer were alerted very early that morning, and both were there at 6 o'clock in the morning, and over 25 high-powered rifle shots were shot at the front of the building from about 40 yards out. That scared me. It started a process, and I've been fortunate that Chief Justice Fader has agreed and his predecessors agreed of hardening. Even before what the chief was just talking about with the tragic death of Judge Wilkinson, we had embarked on a hardening of our courthouses. And if you go to the Essex courthouse today, you will see bullet resistant glass on all of the outsides, including some of the interior clerk locations, as well as the commissioner's storefront and things like that. So and I agree, bollards is in all likelihood a best practice. Our teams have already been out. The security teams for both the district court and the AOC have already started these surveys of each courthouse, and they walk with the courthouse leadership and other stakeholders to go. I believe it's a 175-point survey that they're looking at that runs from cameras to lighting to bollards to bullet resistant glass to how judges get from the courthouse, how employees get to the courthouse. Everything, and these guys are security guys, so they know much better than I do, but we're very committed to that. And together, Essex and the death of Judge Wilkinson have really rattled us, quite frankly, me personally.
Well, it's terrible that it takes a tragedy or something to move forward. It should never come to that. And when I've talked to those officers, that's exactly what they were stating, how they didn't have any type of surveillance. And it was not there. And it was something that probably could have helped that out. So, but I mean, if we could work not with our state people, with our local people, maybe partner in ways where we can do better and protect you and everybody else. It should be a big priority, but I want to thank you for what you're doing. But if we could do more, let's work together to do that.
Thank you.
Thank you.
Just because obviously you're going to take these recommendations to the capital budget subcommittees in the future, do you have an estimated timeline on that report?
Well, so a lot of the work that is being done now with those surveys is being done to and will inform the work of the legislative task force that we hope is in place July 1st of this year. So a lot of that we hope to be able to provide a substantial amount of that information from day one when that task force gets into play. Now, it's different because our budget can cover the district courts and we do have monies in our budget to provide some grant funding to circuit courts, but of course, circuit courts are funded primarily by the local jurisdictions, and so that so where that money would go is a subject that task force is being charged with trying to figure out a legislative proposal for the 2025 term to figure that out. But that's the additional complication with the circuit courts.
Thank you. Okay, I'm going to switch tactics, switch gears here. We mentioned sometimes we find policy issues within the budget. Sometimes we find budget issues within policy. And sometimes, unfortunately, the subcommittee has to read about budget challenges in the paper. So I'm referring to the Washington Post story just a few days back about, or was it yesterday, about private home detention monitoring. Not a new issue for this subcommittee at all. We've had many conversations with Department of Corrections on this very issue and a kind of general lack of regulations in all around, which has caused a lot of consternation amongst these subcommittee members. Can you walk us through a little bit about how we got here and what we do from now on and what you are looking to both the governor's office and the legislature to help alleviate moving forward?
Yeah, I'm gonna Chief Judge Morrissey can
I'd be happy to address that, Madam Chair. As you all may recall, this legislative body passed a bill in 2021 that was effective July 1st of 2021 that said the state of Maryland said a couple of things, but it said the state of Maryland would provide $5 million to provide for private home detention monitoring. It also said that the counties that have established pretrial can't charge for those services. That bill didn't specify that the judiciary was in charge of that program. The money came to us after July 1st and in our budget. There wasn't a whole lot of explanations. We understood that we needed to take ownership of that program, and we started it October 1st of 2021. There's currently 5 licensed private home detention agencies. They're licensed through the Department of Public Safety. There are some COMAR regs, but it deals only with the licensing effect. It doesn't, there is no regulatory scheme, as you mentioned, over these private home detention agencies. As of December of this last year, we had spent about $4 million of the $5 million, and we had a burn, if you would, or a spend rate of about $100,000 to $140,000 a month. The companies are supposed to submit bi-monthly, so twice a month, but they don't, and they haven't, and there's really no enforcement mechanism for them, not because the alternative would be to say, if we were to deny their invoice for someone that was currently on private home detention, that would result in them being kicked off of private home detention, and that's not something that we wanted to do. Unexpectedly, in the first week of February, we received $600,000 in a one lump sum of invoices. And so that set the bells ringing, and we started moving very, very quickly. And I think then, I can't speak for the private home detention agencies, but I think they all realized that the number was getting close to 5 million, which was the allocated amount. And so then shortly thereafter, we received another chunk that put us over the 5 million, all within a period of a week. That triggered us to send letters to the private home detention agency saying, the first letter, I believe, was on a Tuesday that said, we're getting very close to the amount. And then because that triggered them filing additional invoices, 3 days later, we had to say, we believe we haven't paid out the 5 million. We have invoices that would come to the 5 million. And we have additional amounts above that $5 million of probably $300,000 to $400,000. I say probably because when these invoices are submitted, they're not always paid dollar for dollar. We do an audit of these. We are both AOC and the district court internally, finance departments looks at the invoices to try to do an initial screen. This only involves pretrial home detention. It does not involve parole. There can be other instances, our post-conviction probation where there's home monitoring as a condition of probation. It does not include all that. It only includes pre, and a lot of times we'll get these invoices and it's a dump of things. And so we have to go through them and parse through them. And then we send them out to the field to audit the order time. So if a judge says in court on a Monday, I authorize private home detention, we need to know when the hookup date was, because there can be 3 or 4 or 5 or longer days in between the time. And we didn't want to be paying for time that they weren't actively on private home detention monitoring. And then we have to have, if it transfers from the district court to the circuit court, we have to track that and follow it up. And then we have to have verification of when they come off of that in order to approve the bill that we're going to pay. So that requires a ton of resources on our part. And that's why I say it can vary. So we may have $5.5 million worth of pending invoice, but we may only pay 5.3 million of those invoices because some of them are invalid and we won't pay all those.
Okay.
We have been in touch down here with if there's the concern. There's a number of concerns. The concern greatly is we estimate about 650 individuals. We terminated the program on Friday, this past Friday, because we knew we were out of money. The concern is for those individuals that are currently in the pipeline right now on private home detention, in what it would take to get funding for that particular issue to keep those individuals still on private home detention. We had a conversation with the agencies on Tuesdays. I outlined all this. We've spoken to representatives of leadership here and on the House, and we're hopeful that there'll be some solution to that bridge funding, if you would, to ensure that those individuals that are currently on are funded through whenever they come off of private home detention. We estimate that to be $2 million.
To get us until what date certain?
That's an impossible date for us to know, but because a person can be on pretrial right now. In the district court, they're going to come much quicker because we're a faster paced court. Right. But the circuit court, it could be for another year. But we think that 2 million will cover all those individuals that are out there.
The 2 million is not intended to get the program to a certain date. It's intended to get everybody who's currently benefiting from the program to the end date of when they would be on
and
it.
Assuming no new.
It was not.
That's why I said the program was terminated as of Friday.
Right.
We sent notice to the agencies that we would not be paying for anyone starting Monday, but anyone that was a court ordered approved by this past Friday, we would hold them, is what we told them. We have all the invoices kind of there if they're going to submit through that Friday, and then depending on whatever happens with our funding, then hopefully we would be able to pay them, is my hope. Now that does not address the answer of what happens Monday for new individuals that are arrested that potentially could be available for private home detention, but there is no funding nor program for that in statute or in the court.
Let's break this down I think it's important that we understand what went wrong and what we need to fix moving forward. And then we'll discuss the budget solutions here. So I wish this were the first time we all sat in this subcommittee room and heard somebody at your desk telling us we're about to hit or have already hit a fiscal cliff. So I think moving forward, budget leaders would appreciate a little more forewarning so we could fix a problem before. And I appreciate you had a bit of a run on a bank from the providers. At the same time, without having proper regulations around billing and prompt payment of billing or prompt billing in the first place, we have a bit of these are some budget principles that we lack here. I understand that you didn't ask for this program. You were voluntold to handle this program, but at the same time, a little bit of this heartburn is self-created because sounds like we don't have the regulations to make sure we're being billed in a timely manner. So that's a challenge, I think, regardless of the longer term solution, we would like to work with you to fix so we don't have this fiscal cliff, again, 6 months from now. Okay. $2 million gets us the 650
or so people.
Okay. Okay. And your conversations with the governor's office, with DBM have resulted in what kind of solution here?
We made them aware of it last week. I don't have a solution as I sit here today.
Okay. So the challenge, and the subcommittee members know this, we only have the power in the budget, both with a fiscal 24, which is what you need, solution, and a longer term fiscal 25 solution. Either way, that won't be official until we pass the budget, the governor signs the budget, it becomes law. So we have about a 2-month problem on our hands at the moment. Do you have any kind of creative solution to bridge us from now until the budget becomes law?
I do not, as I sit here today. The contractual undertaking from the agencies to us is that they have to attempt to work out a payment plan with their clients if they're capable of it. And if they're not, then they need to notify the court, and we would conduct a hearing then as a kind of review of the current determinations. How long that takes, it will take some time, but I can't guarantee you that would take more than 2 months. Okay.
I appreciate you agreeing with Jacob's recommendation, or at least not resisting the recommendation, to cut 5.6 million of fiscal 25 to better align with actual spending. And from my understanding, that's kind of been a trend line for the judiciary of having around $5 million of unspent funds that we typically take back because they're not being spent. So that suggests that perhaps you have some room in your fiscal 24 budget to perhaps provide that bridge.
I thought 5 million had been cut from that before, but
For FY 24, we did get a $5 million cut.
Okay.
At the beginning of the fiscal year.
Okay.
I haven't yet received an analysis.
Okay.
Of where we are actual to budget to be able to secure that amount of money to not allocate to other judiciary functions, but to allocate to private home detention monitoring. So we can certainly do an analysis, but it's got to come from somewhere.
Okay, thank you.
And there's also an issue of that we have no authorization to pay this because the program ended per the statute. It either was at $5 million or at the end of the year, December 31st of 2024. And those were CARES Act monies.
Right.
Yeah. So
even if we were to magically find and have the ability, which we don't have, to give you $2 million for the bridge for these 650 individuals, you're saying that you cannot move forward with the program based on the authorization?
I would need some authorization to come with the budget money to say, this is what you're, if you want to segregate it or whatever you wanted, I would need some authorization to say you can spend it on this amount. Because it's, when you think about it, it's a judicial branch function paying an executive branch function or an outside agency. It's not something that the judiciary is typically has done in the past. That's why that was kind of why it was it was an unusual program, I guess, that we ended up with the management of it.
I appreciate it's been a bit of a political hot potato between you and DPSCS, and no one seems to want to kind of own this issue. And that's not a judgment. That's just kind of what the subcommittee experiences.
I do have ideas on, we tried as the judiciary, I believe it was in 2019, we had a pretrial summit where the idea was to bring public defender, state's attorney, a judge, a +1 from the county based, hopefully the county executive, and a lot of them did show up, to get together to try to, as best practices, encourage all of the locals to spin up pretrial release facilities as part of some type of pre-trial release. Even if it was a phone call, we believed very strongly that that's best practice and that's needed. It's a tool that the judiciary needs. We did get some tract on that, but there are still some jurisdictions that don't do it and won't do it. And part of the existing statutes are that says that a county can spin up a pretrial release system for nonviolent offenders. But I can tell you that that's not the paradigm has changed over time. We don't put ankle bracelets on people that typically aren't violent. Those aren't the population that we're using monitors on. These are the people that, it may be a robbery with a history of priors, but there's a lot of factors that go into it, but you can see it would be a more serious type of case that may very well be considered a crime of violence, but yet would be appropriate for of home monitoring. So I think the authorizing statutes are going to need to change too. And that's a matter of how much risk individual counties, and it's unfortunately a county by county basis, how much risk they're willing to assess. For all the faults that the system has, it does work in instances. We don't like some of the noticing provisions. We think they should be stricter. We think that there should be the ability of police to arrest on a violation of private home detention, so that there's not this process of the company notifying the court issuing a warrant. If it's an on view, the police can. That may be an education issue, but there's a lot of work that needs to be done around this. We would be happy to participate with you all in this.
That you and I share similar concerns, particularly around notification of somebody absconding. And unfortunately, my district experienced the worst of the worst case when that happened right here in Annapolis a few years ago. And so I think this subcommittee appreciates how serious some of the gaps in the system are, but also how important it is to make sure that we don't have two systems for some people who are of lower income and some people who are of higher income. So again, we're going to have to strike a balance here. And just for the folks viewing at home, as much as I think the General Assembly wish we could, we can't snap our fingers and suddenly reauthorize and give you the ability to continue the program, short of emergency legislation, which still is going to take 2 weeks if we were to do that. So we have a bit of a pickle in front of us with the 2-month problem to solve, and then the longer term problem to solve. Do you have any estimates if we were to keep the entire program going to July 1st, 2025? So through fiscal 25, what would that price tag look like for the state?
We'll have to, I'll try to get you an estimate of that through the end of this fiscal year, Senator.
I would say 25. Yeah, 24 and 25. Okay. So the next, is that 18 months? A little less, 16 months. That one, I think we would appreciate as fast as your folks can calculate it.
I think we can get that to you quickly.
Okay. Further questions on this issue? Okay. Again, disappointing to read about it in the paper. I know it came as a surprise to you relatively. We are better partners to everybody when we're all working together to solve a problem. So I just appreciate moving forward that we're going to do that. The Senate is committed to working with the House to finding a long-term solution, and committed to working with you and DBM to finding that short-term solution we just discussed, but it's going to be a team effort. There's not one individual who can save this situation.
There are 2 bills in the original legislation. There was supposed to be a work group, and that just was never formed for whatever reasons we don't know. But there are 2 bills pending that have a creation this year, and hopefully those will come into fruition. And we'd love to be partners in that.
Yeah, so Senator Hedelman's bill 2 years ago that was never implemented, unfortunately, a work group on the gaps that you just discussed that again are deeply, deeply concerning to the subcommittee and to JPR as well. So let's hope that we can work on the short term and the long term structural budget and policy challenges of the system.
Yeah, and I think as I understand it, the original work group didn't even have us participating in it, right? And I think that speaks to the issue that we were viewed on the outside of this. We would very much like to be part of any work group that gets formed on that.
You have the commitment of the subcommittee to make sure that happens.
Thank you.
Okay. Thank you very much. Okay, thank you. Okay, thank you. Now we have the subsequent injury fund with Elizabeth Wabel. Thank you, Elizabeth, when you're ready.
Thank you, Madam Chair and members of the subcommittee. I'll be presenting the budget analysis for the Subsequent Injury Fund, or SIF, which compensates workers who have had a workplace injury that worsened a pre-existing condition. On page 1 of the analysis, you'll see the fiscal 2025 allowance increases about 8% to $3.1 million. The agency's budget is entirely in special funds that come from a 6.5% assessment on certain awards and settlements made by the Workers' Compensation Commission. And this funding covers both operational costs and the fund balance, which is used to compensate eligible workers. On page 2, Exhibit 1 shows 85% of the allowance is for regular personnel. 2% is for contractual personnel, and almost all of the increase in the fiscal 2025 allowance is due to cost of living adjustments and salary increases for personnel. I'll turn to the key observations starting on page 5. The revenues from assessments decreased slightly in fiscal 2023 due to the value of awards and settlements made by the Workers' Compensation Commission. That decline was partially offset by a large increase in interest earnings on the fund balance. Exhibit 4 on page 6 shows the growth of the fund balance over time. You'll see that the balance grew 6.4% in fiscal 23. And there was also a period of slower growth in fiscal 2021. That's the year that the legislature reduced the assessment from 6.5% to 5.5% for that year only. And that 1% was diverted to the uninsured employers fund to assist with its declining fund balance. On page 7, Exhibit 5 shows the cost per resolved claim. The cost has been increasing as overall operating costs have risen somewhat, and the number of resolved cases declined in fiscal 2023, which has led to a higher cost per case. However, revenues do continue to be higher than expenses overall, and so the fund balance is continuing to grow. On page 8, you'll see the DLS recommendation, which is to concur with the governor's allowance. And with that, I can take any questions.
Great, thank you. Any questions for the analyst? Going once, going twice? Okay, come on up.
Good afternoon, Senator, members of the committee. My name is Edgar Dodd. I am the director of the Maryland Subsequent Injury Fund, and I'm joined today by Mrs. Rose Hunt, our physical services director, and also Mr. Ken Riot. He is an accountant in our fiscal unit. We thank Ms. Waybell for her excellent analysis, and we agree with her conclusions. We submitted our written testimony online. Hopefully you have that before you. My comments will be brief. The Subsequent Injury Fund enjoys an excellent reputation in the Maryland workers' compensation community, and that is due to the 14 dedicated professionals that the three of us are privileged to work with every day. And our latest actuary study was completed in January of 2022, and the actuary concluded that with the continuation of our current 6.5% assessment funding mechanism, we are well placed to continue our mission of paying benefits to injured and disabled Maryland workers for the balance of this current decade. So with that in mind, we respectfully request a positive committee report on the governor's recommended allocation.
Great, thank you. Any questions? Bingo, you're done.
Thank you so much.
Thank
It's always
you.
a pleasure to come down.
You get the award so far this year, I think.
Thank you.
Thank you. The next one's going to be a lot more interesting. Okay, the next, got it right in front of me. Last but not least, is the Uninsured Employers Fund, and Elizabeth Weibel will present the analysis.
Thank you again. This is for the Uninsured Employers Fund, or UEF. This fund provides coverage for workers who are injured on the job where their employer does not carry the required workers' compensation insurance. On page 1, you'll see that the allowance for fiscal 2025 increases 7.6% to $6 million. Like SIF, these are all in special funds. These come from a 2% assessment on certain awards and settlements made by the Workers' Compensation Commission, and this covers both operating expenses and payments for injured workers. On page 2, Exhibit 1 shows that 59% of the allowance goes toward a contract with a third-party claims administrator, and another 33% of the allowance covers regular personnel costs. Turning to page 3, Exhibit 2, you'll see the largest area of increase is in the allowance for that third-party administrator cost. And regular personnel costs also increase due to cost of living adjustments and increments. I'll turn to the key observations starting on page 5. The fund balance declined in fiscal 2023. This was largely due to a decrease in assessment revenues due to a decrease in the value of awards and settlements made by the Workers' Compensation Commission. Expenditures also increased slightly last year. And this decline is a concern because if costs continue to outpace revenues, then the fund balance will continue to decrease, endangering the fund's long-term stability and ability to meet its obligations to injured workers. And I know that long-term fund stability has been a concern for several years. Exhibit 3, if you turn to the top of page 6, you can see the surplus deficit line, which shows whether the balance is growing or shrinking in each year. And you'll see that there have been several recent years with negative growth. The one year with a large amount of positive growth was in fiscal 2021, when the legislature temporarily increased the fund's assessment rate from 2% to 3% for that year. And along with that temporarily reduced SIF's assessment rate. I also wanted to touch on Senate Bill 216, which was introduced at the request of UEF. That would raise the penalty for employers that do not carry the required workers' compensation insurance. The current penalty is a maximum fine of $10,000, and the bill as introduced would raise that to a mandatory $25,000. However, I understand that UEF and the Workers' Compensation Commission have discussed that further and agreed that language should be amended to set the fine at a maximum of $25,000 instead of making that mandatory. This is relevant to UEF's budget for a couple of reasons. First of all, there's the hope that the higher maximum penalty would deter employers from failing to procure insurance, which would ultimately mean UEF would not be responsible for covering them. And second, UEF is entitled to collect the amount of those fines that the Workers' Compensation Commission sets. So theoretically, this could help with the declining fund revenues. However, the commission typically does not issue the maximum fine. The average penalty is just over $7,000. And the number and value of penalties varies widely from year to year, from a couple dozen to several hundred. And there can also be difficulty in collecting the penalties that are owed. So basically, increasing the fine might help some, but it's not a stable and reliable source of long-term revenue. DLS has asked UEF to comment on whether fines are the best source of an increase in revenue, or whether other measures such as raising the assessment rate should be considered. Turning to key observation 2 on page 7, you'll see in Exhibit 4, the cost per resolved claim has increased quite a bit in recent years as UEF's overall operating costs have increased. These cost increases are driven largely by the third-party administrator contract with a company called Corvell. Other operating costs have also gone up, but the Corvell contract makes up the largest portion of that increase. However, I do want to balance that cost with the effectiveness of how cases are being handled. UEF reports that Corvell has improved the overall functioning of the agency and provides a level of service that the agency would not be able to replicate in-house. They also report that Corvell has increased the number of cases in which other coverage for an injured worker is found, which means that UEF does not have to pay their medical bills. And if you look at Exhibit 5 on page 8, you'll see there's been a decrease in the amount that UEF has to pay in benefits, which does seem to bear that out. So it does seem that there is an increased operational cost, but also a decrease in benefit costs, which seems to be due to more effective case management. I will mention the contract with Corvell is due to be rebid this summer. So in the future, if contract costs or other operational costs were to continue to increase, that could offset the savings from better case management. And so that's something to keep an eye on. The last key observation is on page 9. UEF has 2 findings from a 2021 audit that as of April 2023 have not been resolved. The Office of Legislative Audits found that UEF should exercise better monitoring and oversight of the third-party administrative contract, and the agency should ensure that its accounting system is producing accurate reports for the purposes of monitoring and pursuing collection activities. Due to these audit findings remaining unresolved, DLS recommends restricting $150,000 of UEF's administrative budget until the Office of Legislative Audits has confirmed that each of the repeat audit findings has been corrected. And you'll see text of that recommendation on page 10. That concludes the report. I can take any questions you have.
Thank you very much, Elizabeth. Questions? Okay, seeing none, Mr. Burns. Thank you for your patience.
My pleasure. Those who are last shall be first. Madam Chair and members of the committee, my name is Michael Burns. I am the director of the Maryland Uninsured Employers Fund. I have been the director of the Maryland Uninsured Employers Fund for 7 years and approximately 3 months. And it is a real pleasure to come to this committee today. I say that because of our interaction last year. And I think I will be speaking briefly about Senate Bill 216, but that is if there is a mother that is or father that is responsible for that, it is this subcommittee. We had a long discussion about the issue, and I'll start with this. The issue of funding and penalties. You may recall at that hearing, the Public Service Commission was here, the People's Council was here, and the issues of both penalties and difficulty collecting penalties was raised by both of them. And we discussed it as well. I know Senator Salling in particular was very interested in the Public Service Commission because constituents had been basically bilked on electricity rates. And we all kind of sang the same tune to you, which was the penalties seem not to be effective and they are difficult to collect. So in the Joint Chairman's report, the legislature requested, well, first the chair asked for a brief report from the agency about alternatives. I did such a report for you all. And then the Joint Chairman's report requested a more detailed report about the fines and penalties and other related issues regarding the penalty for failure to have insurance. And let me explain to you how that works and how this works. Workers' compensation is probably the most successful social welfare program in history. It's very simple, and I will get you can each go home and explain to your constituents in one sentence how workers' compensation works. Workers give up the right to sue their employer, and their employer agrees to have insurance to cover them. And that is the workers' compensation system. That is it. Everything else is frosting on a big cake. That's it. However, if an employer fails to have insurance for whatever reason, and I want to emphasize that for whatever reason, because it doesn't matter to the injured worker if their boss doesn't have the insurance because they forgot to pay, or they didn't know they were supposed to have it, or they deliberately didn't have it to save money. That injured worker is still going to be not subject to the benefit of his bargain or her bargain, and they're going to be hurt. And it's important to understand that that can be a long-term detriment to them, because the way the system works is, say a state worker gets hurt, say I get hurt, I report it to the state reports it to Chesapeake starts me in coverage and care immediately. So my injury is triaged immediately. I'm getting care immediately. And we'll use a bad guy because the bad guys are the ones that are the problem, really. So a bad guy doesn't have insurance. So his worker, many of whom are undocumented, many of whom don't speak English, many of whom come from countries where if you complain, you disappear, they don't tell their boss and they're hurt. Or they do tell their boss, who does nothing about it. So this worker eventually files with the commission. We investigate, we find there's no coverage. So we take over. That can be months, sometimes more than a year later. And that's just the way the system is. That is not a failure of the state. It's not a failure of what you've done or the executive's done or what we've done. It's just the way the system works. And that worker, that person is permanently damaged because their boss didn't have insurance. So based on our discussions and the research I did, which is included in the report, and I urge you all to look at it because I went through every state in the country, how they handle this. And I did a chart, which is attached, and I urge you to look at it. And I discovered with some, not surprise, but sadness, that Maryland's $10,000 penalty is woefully low. It's a joke. It's not effective. It doesn't deter anyone. And you can look through this chart and see how. So based on our discussions, based on the report, this agency put in a bill, which the Moore administration supported, for a $25,000 mandatory penalty. And I received a lot of blowback about that because it's unfair to businesses. It's unfair to do that. And I received some discussions from the Workers' Comp Commission. And so, having learned several lessons while I was a member of the lower body here, two of which are something is better than nothing, and take yes for an answer, rather than have the Workers' Comp Commission come in and oppose the bill, which would have killed it. I think we can all agree on that. I agreed to make it a up to $25,000 fine. I will give you my word that if the legislature passes that in that form and the governor signs it, my agency will watch every decision of the Workers' Comp Commission. And should it be evaluated that they are not enforcing the $25,000 fine the way they should, in our opinion, we will be back. Well, I'll go to the administration, of course, for the bill, but we will be back to change it to mandatory. I do want to say for the record, I've been very pleased with Chair Maureen Quinn at the commission. She's done a wonderful job, and we have a tremendously good relationship working together. And as I move into the area of the ongoing issue about funding, I can tell you that Chair Quinn and I have been discussing that matter for months, and we are working together on forming a group to come up with alternatives for funding. And I will tell you as well that I strongly will encourage them to come up with any ideas they have. And we will be here next year, I hope, with comprehensive legislation for you to consider. And I will tell you that personally and professionally, I will not recommend anything to you I don't think will work. And it may be in a report, but I will come and tell you what I think about it, because after 7 years, I think I have a pretty good handle on that and what works and what doesn't. I do want to thank Ms. Weibel for her excellent analysis. It really is. It's excellent. The good, the bad, and the ugly of it. It's mostly good. I will discuss this issue of the ongoing reduction in amounts. We're not an insurance company. We don't write policies. We don't set reserves. That's not what we do. We take anybody who comes in who needs the coverage. That's why it's so, and I kind of feel sorry for Ms. Weibel, because she gets the redheaded stepchild agency here that doesn't get general funding. I'm all special funded, and it's had a lot of problems in the past, which I'm sure you're all aware of. Believe me, I am. And she's got, and the answer to what do you expect in revenue is, well, we're not really sure. What do you expect in expenses? We're not really sure. But I will give you all one small example of how this works and why we really can't predict. I had a meeting with my lawyers yesterday in preparation for today and Monday with the House, and in legislation for 216, our hearings next week and the week after. But an issue came up in one of our cases. Somebody got killed on the job. His employer didn't have insurance. Surprise, surprise. He's got a 3-year-old. We're going to owe approximately $900,000 over the course of that 3-year-old's life until they turn 24. That's just the way it is in a fund that has a balance now of, and Ms. Weibel can explain that better, but it's about $6.5–7 million. We are quite literally one bad accident away from being in danger of insolvency. And I will give you a perfect example of that. I'm sure you're all aware of the accident on the Beltway where the poor construction workers were killed, 6 of them. And if you've seen the video, it just shows how life can be. It's one of the most amazingly bizarre coincidental injuries you can ever see. But they were all killed. Had those people been working for an uninsured employer and not killed and just seriously injured, $2 million a year. Right there. Easy. $2 million. Nothing we can do about it. If we can find coverage, and I'm pleased that the analyst pointed this out. When I got there, our sort of TPA at the time was finding coverage in 9% of cases monthly. Today, it's 58%. That's a 640% increase. And you have to remember, although we base it on 100%, obviously, a lot of these cases, there is no coverage. So it is at least 58%. For all I know, they may find all the coverage they can find. That may be it. Maybe that's it. But clearly, and you can see it as Ms. Wybell's excellent analysis points out, the cost of these of our payments out have reduced about $3.5 million, and the funding budget for the TPA is it's gone up, I think, to 3.4 in the last year of the contract. So they literally pay for themselves with that. And I will not go into the investigations. Having served here, I have great respect for you all. And I believe in being honest. I mean, really honest and not playing games. So I will tell you, there is an easy answer to our issue of funding. It's the same answer I came with in 2020 and 2021. It is the following. Between us, the SIF and the UEF have an 8.5% assessment. They get 6.5%, we get 2%. They are flush with cash, to put it bluntly. You can go to their website and you can pull down this chart, which I highly urge you to do if you have the interest in it. It goes from FY 2019 to projections for FY 25. The subsequent injury fund balance when FY 2019 started was $95 million. It is projected in FY 2025 to end up at $132 million. It's mainly due to the fact they don't pay medicals. We pay medicals. That's where the money goes. If it were just assessments for compensation, we'd be fine. Medicals are very expensive. And as you all know, because you're a budget committee, the cost of everything in medicine goes up and up and up, and it costs. And so we pay it. We don't, when we have coverage, we treat our injured workers like they were our own. That's our job. That's what we do. So we don't try to skimp. I don't try to, cut corners on it. They get great care because they're entitled to it. The subsequent injury fund does not need a 6.5% assessment anymore. And I would point out to you, and this is not criticism of the SIF. I mean, more power to Ed Dodd and his group. I wish I were in a position where my fund was going up $5 million or so a year. They don't need the money. But over time, things have changed and the UEF does need the money. And that's just the way it is. And like I said, I'm an honest kind of guy. I'm telling you the way it is. There are two issues about this. One is just how high is the SIF fund balance going to be allowed to go? I mean, look at it. 5 years, 10 years, 20 years, 150, 200, $250 million. What's it ever going to be spent on? I think that's a legitimate question. What's it ever going to be spent on? If you reallocate the assessment to 3.5 and 3 and 5.5, you hold the insurance industry harmless. They don't pay another penny that they wouldn't pay otherwise. It solves the problem, and it will not bankrupt the SIF. And in fact, it seems to me that good financial management and good sense indicates that a program that perhaps $1 million or $2 million a year coming from the fund, lowering their balance, considering the large nature of the fund balance, would make good financial sense. I'll also point out something to you I just noticed, and I apologize for just seeing it, but one of the things I learned when I was here was to try to really take time and look at things, and sometimes you'd be surprised. I'll point out to you that in FY 23, and the analyst did a great job of pointing this out. That's why I looked. It was because you said it. That's why I did this. The fund, the subsequent injury fund, received interest on their $120-some million of $3,663,817. If you reduce their assessment by 1%, it will go down between $3 and $4 million. So it's entirely possible, based on their own numbers, that the interest will cover the change in the assessment, and they will never spend the money. So that's what I'm going to recommend. We are going to have a work group. We're going to come to you. As to the audit, I couldn't agree more. I had a meeting with my staff yesterday. I will be more than happy to continue working with the OLA on that, and hopefully we will get exactly what they want and take care of it. And certainly, if we have not done so by November 1st, I can understand the legislature's desire to penalize the agency. I think it's entirely appropriate, and it has certainly our blessing. I will continue to work with them as much as possible. If you have any questions, I'd be happy to answer.
Okay. Ms. Burns, thank you. I always appreciate your straightforwardness when you come. And before I get to Senator Rosepep, just quickly, it sounds like you are going to have a work group with the subsequent injury fund and workers' comp.
Yes.
Okay. Informally, do you need our urging at all?
Chair Quinn has talked to Chair Vital
Okay.
about this issue.
Okay.
And they started in October talking about it. Chair Quinn has sent a letter to various people about it. I don't want to step on toes about that. I just am in agreement to do it.
Okay.
Chair Quinn is the one setting it up.
Approximately how long do you think you will need to work? Just obviously, you know this better than anybody. We operate on some pretty strict timelines, so we don't want to get a report in late January of next year.
Exactly.
To not be able to take real action or build consensus around. So when do you think you could pull all those recommendations together?
I want to give us time. Well, I'm a one-man show there. I do a report for the governor. It's due October 31st. So I would think since we have one November 1st deadline, would another November 1st deadline work for you all? It's fine. I think
it works for us.
I really do. I'm a strong believer in one of the sayings of Mao Zedong, let 1,000 flowers bloom. And I want as many ideas as possible.
Yep.
I have a lot of ideas. Senator Roosevelt can vouch for the fact I'm quite the idea man.
Yes.
And I want to take advantage of this group to have as many important changes presented to the legislature as possible.
Well, while we have everybody kind of in agreement that something needs to happen.
Absolutely.
I think we got to take advantage and strike while the iron is hot. Last question, if you could do me a favor and share with Chair Gazzoni that sometimes our JCRs from this subcommittee are in fact really impactful, because he complained to me about the size of the stack last year. So I'm glad that this JCR resulted in the bill in front of finance. So
Senator, I've had to do several JCR reports. This is by far the most profitable and positive I have ever been requested to do. And I will tell you the God's honest truth. I was delighted to see it in the Joint Chairs report.
Do me a favor, just
I will
let Senator Gazzoni know that, please. Thank you. Senator Rosepep.
Thank you. Good to see you as always.
You as well, Senator.
This is so complicated and I pay so little attention to it and you know so much about it that I get a little confused. So let me just take things one by one. On the penalty issue, who sets the penalty?
Workers' Compensation Commission. In the past, the chairman of the commission would hold the hearings on. Okay. Let me explain to you how it works and how it's supposed to work. How it works quickly. We get a list from NCCI. It's a private company. Well, we don't get the list. The Comp Commission gets the list from NCCI about entities that may not have workers' compensation insurance. They send out notices to those entities
without regard to somebody being injured. This is just
no. This is going after entities that don't have the insurance required by law.
Right, I understand.
Right. So they sent the notices out to do what are called show cause hearings. They're supposed to appear and explain that they have insurance or whatever.
Yeah.
And so they show or they don't show. If they don't show, they get penalized. As Ms. Weibelt noted, it's a $10,000 maximum penalty. Currently, the usual maximum is $7,000, although no one can explain why to me.
Right.
So that happens. And then that list comes to the UEF who gets the money. So we try to do the collecting. So I have a staff person who does this, tries to collect this money. Now, a lot of these entities don't exist anymore. A lot of these entities we can't find because the addresses are bad. A lot of these entities will have an excuse. And months after the original show cause hearing, there is a rescission of the award. So we've actually had cases where we're starting to collect money, and then they go to the commission with their insurance and say, "See, I had it," even though they haven't shown up and they never answered the commission. And before we start to collect the money, we send them a letter.
I see.
They suddenly, I had similar experiences in the ALJ. People would suddenly appear who never got mail before.
Right.
So that's how it works. How it is supposed to work under the statute is there is this first show cause hearing. And those who do not attend or are fined have 30 days to basically appear and return. And if they don't respond, there's supposed to be a second penalty.
Okay,
It's confusing.
You're getting too complicated for me.
I'm sorry.
No, but I get the basic idea. It's a screwed up mess. I got
Right, it
I
is.
got that part.
It is.
I got the big idea. And anybody who employs anybody is supposed to have workers' comp? Or
Pretty
not
much.
quite, or not
If
quite?
it's
Like
if
who's
it's a
exempted?
family member,
Okay.
you know, if you're a small business with some family members.
I got you, okay.
you're okay. But yes, and it has been the law in this state as near as I can tell since 1914.
Okay.
So yeah, I mean, it's not like it's news to anyone.
So it sounds to me like it's administered very inefficiently compared to the way we administer taxes.
Absolutely.
Is that one of the options that other states do that administer it more like taxes?
In 18 states, entities have the authority to shut businesses down if they don't respond or pay. Yes, yes.
So is that the kind of stuff you want to study in this work group?
Yeah, I would have. Well, another thing I learned here was my wife always says this and she gets it right. Hogs get slaughtered, pigs get fat. I didn't want to come here with too much. I wanted to come here with something really reasonable that I could fight for. And I'd love to have the authority to close. A number of states give their UEFs the authority to close people down. You just go and say, you haven't paid, you're closed.
Well,
that would be effective.
I don't recall you being so reasonable when you served in the House.
Because we were never on the same committee, Senator. I was much more reasonable.
I experienced you as being more forward leaning. And I'm serious about this. I mean, it seems, another question, I guess, is, so what are the fines in other states?
Oh,
ballpark.
In California, it's 100,000 up to 100. In a number, I could read down my list.
Oh, but they're a lot.
Oh yeah, in some states, it's $1,000 a day as long as you don't have insurance.
Okay, well, the picture you're painting is we're kind of at the bottom of the barrel.
We are, in my opinion.
Okay, but you run the program, so you know something about it.
Yes, it's appalling. Virginia, the maximum fine is up to 50,000. It's a right to work state.
Okay, so let me pursue this if I might. So when you propose these increases,
yes,
and when you proposed sharing some of the money with the other fund,
SIF, yeah, yes.
What are the arguments on the other side?
It's unfair to business.
To obey the law?
Senator, welcome to my world. Okay. That's all I can tell. Seriously, yes. And you and I have had, in fact, last year you brought this up that you said, you weren't nearly as pro-worker when you were in the legislature. and I won't answer that, but I will say, if my choice is to protect injured workers or businesses who violate the law, my choice is easy.
Yeah, absolutely.
It's easy.
Okay.
And I mean, these people don't deserve this, and it's got to be stopped.
I'm with you. Last item, just so I understand where we're going with this. So this work group, which people have agreed to sort of, will address all of these issues?
Oh, yeah. Well, yes, sir.
Okay.
That is the intent. Yeah, absolutely. They will be brought up. I can guarantee you that. Whether they will be recommending it to this legislature, I cannot say. But I intend to bring up a number of issues. Yes, sir.
Okay.
And I think Chair Quinn is with me on a number of them as well.
Okay. Well, I just free advice with you paid for it. I would encourage you to be forward leaning. I mean, you know a lot about this. You've worked on this a long time. What you say makes sense. And it seems to me we got to make some big changes.
Yes.
Thank you. Thank you, Madam Chair.
Thank you. And forgive me if I asked this question last year, but do you have a habit of repeat offenders?
Oh, yes.
Yes. And do you have the ability for escalating fines with those repeat offenders?
No. If you're talking about the penalties for failure to have insurance.
Yes.
No, that's all workers' compensation. We just collect the money.
Okay.
But we've seen that in the past. Yes, people come back.
Could you possibly look into other states if there is an escalator?
Yeah.
For
yes.
For this, obviously, I think to your point, it's supposed to be getting at the worst of the worst actors. I mean, all bad actors, but we want to ensure that folks who are truly taking advantage of the system, we make it very uncomfortable, if not impossible, for them to operate business in the state.
You're correct, Madam Chair. You really are.
Well, we look forward to working with you. We look forward to that report.
It is a delight to come here. Thank you so much.
Thank
It
you.
really is. Thank you.
Okay, everybody, that concludes our hearing for today, but wait, we are here again tomorrow at 11:30 to hear the 4 budgets, corrections, Department of Transportation Transit Authority, Department of Natural Resources, and the Comptroller. So bring your lunch. We are adjourned.